Hi everyone. Welcome to the little mini lecture on it's on competency. I know this unit is competency and insanity. And I'll briefly talk about insanity to begin, but most people are aware of what insanity is to some degree. Competency is typically the part that is kind of new information for people. So insanity, it's something that's played a lot, again, in mainstream. So television and movies love the idea of, well, they're just going to plead insanity and they'll ultimately get a lighter sentence, or they'll win their case and not have to serve jail time. And those are just kind of major myths about insanity, please. Um, for insanity to work, and this is where it becomes very challenging. Most insanity cases, if that's your defense, you don't actually win. Most of the time, the jury will still convict you. That's because for insanity, you need to prove that at the exact moment the crime happened, you were not of sound mind, and that is a very challenging thing to do, which is why, again, insanity defenses typically do not work. Now, many people will use the term insanity incorrectly. Um, Insanity is a legal term, not a psychological term. So you'll never hear a psychologist talk about a patient being insane unless they were hired by the court to evaluate that. Um, but that's what insanity is. So not being of sound mind at the instant the crime actually happens. One of the most famous insanity cases is Lorena Bobbitt, who she ultimately won her case, and did not actually have to serve jail or prison time either, which is fairly rare. But what she did is she cut off her husband's penis, and the reason she won her case for temporary insanity is because after she did it, she took it, drove away, and ended up throwing it in a field. And about 10 minutes later or so, she kind of comes to her senses and decides, I'm going to call police and help them locate it. And it gets reattached. And, that act in the mind of the jurors said, yes, when she did it, she was not of sound mind. Once, time passed and she got clarity, she did the right thing. So we do think that she was temporarily insane. She was also abused regularly by her husband, which I'll talk about when we get into the domestic violence stuff in a couple weeks. But yeah, so that's insanity again, just because it's so much is out there about insanity. This lecture is really more on competency and what that means. So competency typically is determined before a trial will happen. So this would be during the pretrial or the hearing. Um, and the concern here is, does an individual have sufficient present ability to perform necessary personal or legal functions? So necessary personal and legal functions are things like aiding their attorney. Are they able to understand the procedures of a courtroom? Um, are they actually able to recognize and understand what a guilty plea would mean? If you ended up watching the Central Park 5 jogger video, you'll see that for a lot of the teens that confessed falsely to the crime, they don't understand what the punishment actually is for what they're going to be charged with, right? Like some of them are like, well, I just want to go home, and you're being charged with attempted murder and sexual assault. Like you're not just going home. That would be a competency issue of, do they actually understand what they're being charged with and what degree um, of severity this actually is. So other types of legal competencies, you have to have it in order to waive your Miranda rights. And we talked about that, how the vast majority of people will waive their Miranda rights. You need to have legal competency to confess as well. And this is a little troubling because it's typically found out about competency after the interrogation process. Now, during the interrogation process, certainly officers can get a sense of like, okay, they're just they don't seem to understand what is happening. Um, they don't seem to be able to follow the questions well, and it will ultimately kind of trigger. There's probably going to be a competency issue. But again, somebody can still make a confession, and then once they go to their hearing, people can start to say, "I have concern about competency," and then decisions will be made after that. Make treatment decisions. So this is both medical treatments for non-mental conditions as well as for mental conditions. To executive a will or contract. So um, you need to be of sound mind in order to do this. And the process is also somewhat lengthy. So you can't have somebody who is deemed incompetent writing a will that gives all their possessions to somebody or anything like that. And then take care of oneself or one's finances. So again, these last two we typically see much more with the older population when it comes to like dementia, Alzheimer's. There's concern of do they actually know what it is that they're doing, and so we have to kind of look at their competency levels. So when we look at competency to stand trial, so this is where if somebody commits a crime, they will ultimately be figured out, are they competent to actually stand trial? And this means help their counsel understand the charges, understand what pleading guilty versus not guilty means, all that type of stuff. And in the video that you'll watch for your discussion, you'll see that people bring up some issues regarding competency. Um, so some of the concerns from kind of the other side. So in the video, they mentioned concerns about having to be so low that, to pass competency standards, just about anybody can do it. The flip side of that concern, just kind of balance it out, is if we have high standards, may cause people ignorant of the court system not to stand trial, right? So they are fully competent, but if we were to make the bar so high to pass, ultimately we're going to run into issues on that end that people just might not know all the fine-tuned things of a courtroom, which the average person doesn't. I mean, the average person um, will not ever see a courtroom in their life. So if we were to make that a high standard, we then slow the process even more. And we're already backlogged when we look at all of the um, court dates and hearings and everything else. That this is, if we were to have it too high, is also going to make it even more backlogged. Participation in one's own defense optimizes chance of just verdict. So this is the concern for having competency be a little bit better, not so low, is that we know if somebody actually participates in their defense and actually assists their attorney, that the outcome is more likely to be just. It doesn't mean that they have a higher chance of winning, which my gut tells me they probably would. I haven't seen any hard data on that. But what we can say for sure is that if they're able to work with their attorney and tell their story, it's going to be a more just verdict. And then legitimacy of legal system undermined when competency to stand trial standard is unfair. The legitimacy part here is that most people feel comfortable in saying that we should only charge people for things that they knowingly did that were wrong. And there's major crimes out there that we have the standard that absolutely everybody should know that that is wrong. Other things we kind of turn a more like, all right, is that really such a big deal? Um, something like jaywalking. It is a crime. Almost everybody does it, but do people actually understand what that is? And should we be arresting people for that? That's obviously on the much lower end of things. But if you're unaware of a law and it's not one of the big ones, and I'll use a personal example. So from Minnesota, which is where I'm from, when I moved out to Washington, there was a difference in cell phone laws and cars. Minnesota, you could use them. Washington, you couldn't. And Minnesota now has the same law that Washington does. But I remember using my phone in my car, and one of my colleagues saw me and was like, "Just to let you know, that's actually illegal here." And if I got pulled over, could I have justified that? Well, I had no idea. Sure. And they may or may not have believed me, or they might have said, "Well, screw you. It's your fault. You should have known our state laws." But that's where police discretion kind of comes into play. But most of us would argue, like, no, we don't want to punish people that don't know that they did something wrong. And again, obviously, there are limits to that. That if somebody's like, "I didn't know murder was wrong," no, right? Most of us are not buying that. But if the lesser thing, most of us would be like, I suppose I could see why you would think that. Um, so that's where, competency and trial kind of gets this legitimacy concern from, is we want to have people get punished for things that they knowingly did wrong, and that we agree that should be a punishable offense. So competency to stand trial, legal, not psychological. It does not certify mental health or functioning. And this is one of the big things that people get confused with both competency and insanity, is that if somebody is already mentally ill, that we know, well, they go and see a therapist and they're taking this medicine. So that means that if they do a crime, they can plead insanity. And again, that's not the case at all. You need to prove that you were having an episode at that moment, which, even if you have a long history of seeking mental health assistance, it still is very challenging to prove that at that moment you had an episode. Competency to stand trial, again, doesn't really tell us anything about their mental health or functioning, because it might be that they are so whacked out on drugs that they just need to go to detox for a little bit longer. Um, it could be due to something else that is going on in their physical body, that just mentally they're not there. And once we fix the physical thing, mentally they come back. Um, but it includes the defendant's ability to perform 10 court related functions. And these functions typically are things like, um, can you tell us who the person in the black robe is? Can you ultimately understand what entering this plea actually is? Do you recognize that the person next to you is your attorney and what their role is? Things like that. So again, fairly basic, which is somewhat of a concern. But again, we don't want to go too high, otherwise we have a different concern on our hands. So these are just different court cases that ultimately highlight what competency means to do a couple different things. So guilty plea must be knowing, voluntary, and intelligent. So if somebody enters the plea of guilty, they ultimately, if there's any concerns about competency, will be evaluated to make sure that they are competent to do that. Now, if there's no concerns about competency, that process is kind of, it's done much more quickly, I should say, because you're not going to have to go through the whole competency issue. Again, competency only gets raised if either the attorneys, police officers, or judges kind of have reason to raise it. Um, Most people aren't going to be able to recognize that they're not competent to stand trial if, in fact, they're not competent. Competency to waive attorney or competency to plead guilty not required once the defendant's competency to stand trial is found. So if somebody is deemed competent to stand trial and then at some point they decide, okay, I want to waive my attorney, or I am ultimately just going to plead guilty at this point in time, they won't do another competency test. They will just say, nope, they were found competent to stand trial before. There's no need to do it again. And higher standard for the mentally ill to waive counsel set. So if you do have a history of mental illness, um, and it will be brought up in court, and you decide that I don't want an attorney to represent me, they're going to ultimately make the standard to waive that counsel much higher. Now, it might mean that you don't like that particular attorney and you can switch. That's fine. But if you're going to ultimately defend the case yourself, then yes, much, much higher standard for somebody with a history of mental illness. So, attorneys guided by ethical guidelines to inform if defendants thought to be incompetent. Again, attorneys, police officers, and judges are typically the ones who be thinking about competency. Um, Evaluations are only introduced if defendant places mental state into evidence, um, and defendant not having to be the actual defendant. It can be the defendant's attorney. So really, it's the defense places mental state into evidence. Competency to stand trial, typically raised at pretrial hearing unless bona fide doubt about defendant competency. So the bona fide doubt would be they get arrested in interrogation, police recognize like something is absolutely not right with this individual. We cannot get any type of actual, coherent statements from them. That's going to ultimately kind of be that bona fide doubt. If they're not getting that, if they're like, all right, well, the suspect is really slow in answering things, and certainly intelligent wise doesn't seem to be great, but they're kind of following along, then it is going to be up to attorney or judge to raise it in the pretrial. So this is one of the jobs that forensic psychologists can get, if ultimately you're finding this stuff kind of interesting, is both a competency to stand trial evaluator as well as an insanity evaluator. So interviews defendants, administers psychological tests, reviews defendant history, and writes a report. And the report then goes to the judge, which again you will see in the video. The judge will read it and, based upon the report, make the decision. Is this person deemed competent to stand trial? Yes or no? But the evaluator's job is to take what they know, what their expertise is, and present it to the court. Now, there's sometimes that absolutely the evaluator will say they're incompetent, and the judge will read that and say, all right, well, the evaluator says incompetent, we'll postpone this for 6 months or whatever length of time it is. Other times, and you'll see this in the video, the judge will get the report and ultimately just kind of dismiss it and say, sure, evaluator said they're incompetent. I don't think they actually are, so we're going to go ahead with the trial. Evaluations currently contain more links to defendant mental illness and trial-related deficits. They go through changes over time, and so if you were to look at a competency to stand trial evaluation from 1970s, you're going to see a lot of different things being highlighted than if you were to look at one from 2020. Often fail to tie explicit connections to specific competency abilities and deficits. This is ultimately going to be one of those things that until you're trained well and you've done it for a long time, many evaluators write these as a clinical intake, and that's not what it is. It's your job to tell the judge, here is all the concerns and how it relates to court-related functions, not just, well, it looks as if the individual might have early set of schizophrenia. The judge doesn't really care about that. It's not in their realm of concern. Their concern is, can they perform the functions? And if it's not explicitly there to say that, then the judge is kind of up to his or her own discretion. So it's something that has gotten much better, but we still see it enough that for anybody that's thinking about going into this, I want to make sure it's understood that it's your job to explain what that might mean for a courtroom setting, and then are rarely rejected by the judge. And this still holds true despite what the video shows, where the judge actually rejected it. Most of the time, the judge will read the report and just kind of say, all right, well, the expert says this, and that's fine. We'll delay the trial, because competency to stand trial doesn't mean that if you are deemed incompetent, you then get to walk. Um, there is a very long process that ultimately you still have to go to trial. It's just that the process will hopefully get you competent enough to stand trial, and then whatever happens in trial will happen. But yes, this is not a get out of jail free card, just like an insanity defense is not a get out of jail free card. So evaluations ordered at any time during the trial, but again, we typically do see it in pre-trial, completed by mental health professionals. It can be either outpatient or inpatient. So inpatient, it would be somebody who is there's a lot going on in that individual. Outpatient, you can do it in an hour or two, but inpatient, there's just you need time to see these individuals for everything that might be wrong with them. A judge agrees with the evaluation about 80% of the time. It is actually higher now. I want to say that statistic is from like 2015 or 16. I think it's up to about like 83, 84% of the time now. And then evaluations may recommend competency restoration. So this is the most typical outcome of an evaluation that says the defendant's not competent, but here's my recommendation, is to do competency restoration. And we'll look at that in a little bit here. So about 60,000 defendants are referred for competency to stand trial each year, and 25% of those are actually found to be incompetent. So you're looking at about 15,000 defendants every year on average. And the characteristics of those that are actually found to be incompetent. So it means 45,000 of the 60 do are considered still competent, and they go to trial despite people having some concerns. It's not great enough for either the evaluator or the judge to agree with it. So characteristics for people who are found incompetent: history of mental illness, drug abuse, criminal behavior, psychological problems. Again, these are very broad characteristics because obviously within every single one of these, there's more specificity that can be had, right? What type of mental illness? Does that mean that if somebody was depressed for a month span after losing a loved one, that they now are more likely to be found incompetent? And that's the trouble with kind of diving into research that is psychological in nature but is housed in the law, is that a lot of times that specificity isn't given, right? Same with drug abuse. Is somebody who's abusing cocaine the same as somebody who's abusing ecstasy? And are they just as likely to stand trial? It typically doesn't get parceled out that much. So we have these very broad categories, but again, what it really means isn't truly that informative. Difficulties that affect ability to interact with attorney and understand court proceedings. Yeah, I mean, again, that's just kind of the hallmark trait of somebody not competent to stand trial. So restoration, then again, just because you're deemed incompetent does not mean you don't need to go to trial. Um, so restoration typically involves antipsychotic medication treatment that have physical side effects. This, as you can imagine, is a hotly debated topic in those circles. Is this ethical to do? Can we just give medicine to somebody who is refusing it? And there's been court cases to look at different facets of yes and no's to that. And because most antipsychotic medication are going to have some type of physical side effect. And it really doesn't matter, to what degree the antipsychotic medicine is. We typically have some type of side effect going on with it. Lack of illness awareness may encourage medication refusal. So a lot of people who are deemed incompetent and are going through restoration, they might not actually think that they have anything wrong with them. And so because of that, they view this as, well, I'm not going to willfully take that medicine. And then it gets into more legal issues of, can we forcefully give them the medicine? And again, that's a whole nother layer of this restoration. The idea of restoration is you get them up to speed to go stand trial, right? It's not that you fix all their problems or anything like that. It's just, are they now able to understand who the attorney is, the judge is? Are they understanding the charges? Things like that. Like that is the only goal of restoration, is not a clinic to try to rehab people. Now, a lot of the treatments that are in a restoration clinic are very similar to what you would see in a rehab setting. But again, the goal is not to, you know, prevent them from drug abuse again, or to fix all of their psychological issues. The goal is to get them to be able to stand trial. So, defendants held in a mental health facility, determination made about restoration to competency in foreseeable future. If not restorable, non-restorable charges may be dismissed. So what this means is, if somebody is just so far gone, they might just dismiss the charges, but then they're going to be involuntarily committed to a mental institute for years upon years if it's that bad. So again, just because we can't get competency restored doesn't mean that they get to just go back to their old life. They will be admitted into a mental institution, which largest mental institutions in the US now are ultimately jails and prisons. So they're probably going to be in a jail or prison, just in the mental health facility that is there. Restoration may include education and treatment. So there are some individuals who it literally is, they don't have competency because they just are, low intelligent, and they just need to be told, like, here's what is happening in the court. Now, again, this becomes controversial because, well, just because you told them that's what happens in the court, and they might be able to regurgitate it back to you, doesn't mean that they actually understand what's going on. But again, this process, if anybody were ever to argue the competency process is perfect, they are lying their ass off. It's touch and go, and we constantly see changes and modifications done, whether that's in the courts or in the mental health facilities. And use of antipsychotic medication is controversial, as I already mentioned. So adolescent incompetence to stand trial, 1990s, we started to see, this higher rate of juveniles being transferred to adult courts for serious offenses. So if juvenile committed attempted murder or, murder, they're probably not going to be housed in the juvenile side of the law. They're probably going to be moved to adult court. And that becomes, again, especially from developmental psychologist point of view, problematic, because you're holding juveniles to the same legal standard as an adult, but ultimately not to the same level of competency. That many times a juvenile should be deemed incompetent to stand trial because of everything that you see listed there, which just comes with age, right? That a 14-year-old is just going to lack maturity, and it really doesn't matter how sophisticated that 14-year-old is. There still is certain developmental milestones that have not happened in that individual's life that they need to develop into kind of an adult mindset. Poor judgment, poor decision making. They're more apt to confess as well compared to adults, and more likely to have false confessions as well than adults are. Inabilities may depend on the age of the juvenile. That certainly, if we're looking at a juvenile who is 11 versus who is 17, yeah, right. Like it needs to be taken into account that the 11-year-old is going to be running at a much higher deficit in these things than the 17-year-old is. They're both considered juveniles in law, but again, there is a difference there. All right, and then last two things. So currently, there's no gold standard for deciding competency to stand trial. In 1971, we started to use forensic assessment instruments, or FAIs. These are just like with the juror stuff, where you had the opportunity to take like the juror bias scale. forensic assessment instrument is going to be something similar. You're just assessing for competency instead of assessing for biases. MacArthur structured assessment of competencies of criminal defendants. This is just another scale that has been used. It's one of the more well-known FAIs, mainly because it was developed by a network of researchers, not just a single individual. This one in particular looks at adolescent judgment and decision making in a variety of legal contexts. And just kind of one of the fun notes is that it does include questions involving hypothetical bar fight. So there's other hypothetical incidences in there as well. But the bar fight one is one that typically gets stand out and kind of it's notorious for. And then awareness of malingering. So malingering we see with both competency and insanity. It's the idea that you're intentionally faking an illness. And typically we see this happen because there's some sort of incentive. And again, if somebody is found to be insane at the moment of the crime, they typically just don't get to walk away. They typically will then be sentenced into mental health facility, and many times that sentence is actually going to be longer than what their sentence would have been if they were just convicted of the crime. But malingering, we see it happen a lot where somebody does a crime and they will ultimately fake like, well, no, I was blacked out at the time, or yeah, I did that, but I don't remember doing it, or I have multiple personality disorder, or whatever it is that they're going to try to argue. So that is called malingering. It's faking incompetence to avoid trial could also be something that you just pretend like, no, I don't understand who this person next to me is, or I don't understand why that person's wearing black. And again, it will temporarily avoid the trial, but you're going to go, or you're going to be in a mental institute for an extended time. Like there is no win in faking competence. Difficult to detect. The competency one is more challenging to empirically detect than the faking of a mental illness. There's a lot of people who will fake mental illnesses and they'll look at the symptoms online and assume, well, that's it. Like, I just need to do that. And that's not the case. Typically, there's much more nuanced things happening in mental illnesses, especially if you're going for insanity defenses, that unless you actually truly are suffering it, you don't know that this is part of it. Whereas an expert in that field has seen, hundreds, if not thousands, of cases of this and recognizes what's real versus what isn't most of the time. We also can do different tests to detect malingering. So this is going to be inventory of legal knowledge, or evaluation competency to stand trial, revise. These things, they do what's known as both reverse coding, which I think I mentioned in the juror bias scale, but also repeating of questions just phrased differently. So you can easily tell if somebody is lying or faking something because they'll start to answer questions slightly different, although they should be answering them the same. And when we get to police psychology, we'll talk about the MMPI, which is a scale that all police officers will have to take. And we'll go over a little bit of that as well, like why is this used and what's it actually trying to do, and things like that. So, but with that, that's it for the competency to stand trial lecture with insanity kind of blended in there. There'll be some videos outside the one that you need to watch for your discussion posted on Canvas as well, that hopefully you check out and that you like. If you have any questions about anything, please don't hesitate to ask.